can come up with the calendar for the trial of the said case. So part na dun sa trial, sa calendar for the trial of the said case, kailan mag-a-appear ang House Panel of Prosecutors. Okay, if we will not touch the original plan of the Senate President, that means a Wednesday pa yun ng, so June 11, Wednesday ng 4 p.m. But of course, we as a court, we can advance that appearance. Simple communication lang naman yun, or notice to them to come here tomorrow. Kunyari, if should my motion prevail.
But such an allegation of that the articles of impeachment is constitutional infirm, and of impeachment is constitutional infirm, and therefore should not be heard. Is that within the ambit or within the jurisdiction of the impeachment court to determine under the Constitution and also as well as under our rules?
Well, in the name of due process and to be fair to the respondent or the impeached officer, we should allow that person to put everything there, lahat ng objections niya against the case against her or him. So, lagay niya lahat doon. Ngayon, we can now debate now as a court. Ang reading ko kasi, trial by the Senate shall forthwith proceed. We will not entertain any motion to dismiss because we should try. But at the end of the proceedings, when we make our judgment, we can, of course, incorporate into our way of thinking, in our reasoning, to help us come up with our final judgment or the judgment to the final question, we can use the arguments presented by the parties.
Thank you, Mr. President. Without going into too much detail of the procedures, I'd like to thank the good minority leader for his enlightenment, and of course we respect his legal intellect, considering that he has topped the bar examination once upon a time. And once again, I thank the body for listening to this.
Why we cannot, as of yet, schedule the impeachment complaint. Much has been said about the term forthwith, which I wrote to each and every member of the Senate. Mr. President, Your Honor, we are governed not only by the Constitution but also our rules. We are governed as well by precedents. We are governed as well by decisions of the Supreme Court pertaining to this matter. Allow me to, for the record, cite a few regarding this matter, lest they may think that it is only a one-sided opinion with respect to their definition of forthwith na agad-agad. Kada senador marahil may kanya-kanyang opinion kaugnay nito. Hindi ko pwedeng hayaan na sa record natin ay hindi maisabi ang ibang opinion kaugnay nito. Una, nakasaad po sa saligang batas kaugnay sa papel na dapat gampanan ng Kamara na dapat tugunan nila ang pagsampa ng impeachment complaint sa loob ng mga takdang panahon. Kung ilang session days para ilagay sa calendar, ilang session days para ilagay sa Committee on Justice, ilang session days para pagpasahan, ilang session days para pagdesisyonan ng plenaryo ng Kamara. Nakalagay din sa rules ng Kamara, anumang impeachment complaint regularly filed by one member, dapat po immediately, hindi po forthwith, immediately, i-transmit ng Secretary General sa Speaker. Nakalagay din sa sariling rules ng Kamara, ang Speaker dapat sa loob ng 10 araw, i-refer sa Committee on Justice. Bakit mahalaga yon? Dahil sang-ayon sa desisyon ng Korte Suprema sa Francisco case, dyan magsisimula ang 1-year ban sa pagsasampa ng pangalawa, pangatlo o pang-apat na impeachment complaint. Hindi yan ginawa ng Kamara. Sa katotohanan, hanggang nag-adjourn tayong lahat bilang Kongreso noong February 5, hindi yan ginalaw ng Secretary General sa kabila ng magkatabi lamang naman ng opisina ng Secretary General at ng Speaker. Sasabihin marahil ng ilan, tapos na yan. Lumipas na yan, tulad ng sinabi ni Senator Coco, wala na tayong magagawa dyan. Nandun ako. Pero may katanungan akong iiwan bago nating lisanin ang puntong yan. Nasaan yung mga nagrereklamong dapat agad-agad? Nasaan yung mga nagsasabing ngayon na, wag nang pagpaliban, ba't ba dinedelay? Inupuan po na mahigit 2 buwan, magtatatlong buwan nga ito. Hindi inaksyonan. Wala naman ako narinig na nagreklamo na nasa na yung agad-agad. Sa kanila nakalagay immediately, may takdang araw pa. Yan ang paksa ng petition sa Korte Suprema ngayon na inihain ni Vice President Sara Duterte kaugnay sa pag-iiwas sa tinatawag niyang 1-year ban na nakasaad sa saligang batas. Now let me proceed to forthwith. I quoted this in my letter to all the senators. Forthwith, citing various cases, Mr. President, Your Honors, means within a reasonable time, which may be longer or shorter period according to the circumstances of a particular case. It means it is elastic in nature and varies with every case. Quote, it may be modified by circumstances and the nature of the duty to be performed. Marami po nagsasabi ng opinyon na agad-agad. Kung gaano karami po ang abogado, kung gaano karami po ang marunong at magaling, gaano din kadami marahil ang kanilang interpretasyon. Pero nasaan ang probisyon ng saligang batas, desisyon ng korte nag-iinterpreta doon na nagsasabing agad-agad nga ang ibig sabihin yan, samantalang hindi naman agad-agad ang interpretasyon ng salitang immediately ng Kamara. Kung talagang immediately ang gusto, de sana ang sinulat ng mga nagsulat ng konstitusyon, immediately din tayo. Yung immediately nga ng House, hindi yun ang interpretasyon. Tapos tayo ganyan. If the prosecutors themselves, the complainants themselves were not that interested and sat on these complaints for over 2 months, tayo bigla ngayon, mamadaliin nila habang nagpabanjing-banjing sila ng mahigit 2 buwan sa mababang kapulungan. Pangalawa, bagaman tama si Senator Pimentel at sang-ayon ako na pwede tayo mag-trial habang recess. Ginawa na po yan sa kaso ni Chief Justice Corona. Again, we are governed not only by the Constitution, by our rules, but also by precedents. Subalit, may malaking pagkakaiba. Dapat nasimulan, na-refer, at nagkaroon ng plenary action sa articles of impeachment upang makonstitute ang impeachment court bago ito magpatuloy habang recess. Maraming nagsabi, mag-trial na tayo, mag-convene na tayo, sumampa na tayo habang recess. Sa pananaw at palagay ko, labag yan sa saligang batas. At dun sa mga talagang gustong matanggal si Vice President Sara Duterte, dun sa mga galit sa kanya, inis sa kanya at gustong madali itong impeachment, para mo lang dinagdag, binigyan siya ng dagdag na balang questionin ito sa Korte Suprema. Dahil hindi po pwede yan. At hindi po ako papayag na mangyari at gawin yan dahil lamang gusto nila at nagmamadali sila. Sinabi ko na sa simula pa lang ng impeachment process na ito, 1 linggo matapos i-file yan dito sa Senado, 2 oras bago tayo mag-adjourn sa huling araw ng ating sesyon. Sabi ko, hindi ako makikinig, susunod o magpapadala sa sino mang pabor sa impeachment at ayaw kay Vice President Duterte. Hindi ako magpapadala sa ayaw sa impeachment at gusto si Vice President Duterte. Trabaho ko bilang tagapangulo ng Senado, hindi nga lang ako, trabaho nating lahat, na maging pantay at pareha sa ating pagtingin. Yan ang rason, hindi naman tsamba lang yun at nagkataon. Yan ang rason kung bakit ang babaeng sumisimbolo ng hustisya ay nakapiring. Wala dapat tinitingnan o tinititigan. Wala dapat kinakampihan dahil lamang nagkataong ganun ang nangyari. At dahil nagkataong ayaw ko siya ganyan ang gawin nyo. Let's go back to presidents, Mr. President. 3 lamang na impeachment complaint ang naitawid ng Kongreso patungo sa Senado na inabutan ko na matapos ang 1987 Constitution. 3 po lamang. Ang impeachment complaint laban kay dating Pangulong Estrada, ang impeachment complaint laban kay Chief Justice Corona, at ang impeachment complaint laban kay Ombudsman Gutierrez. Hayaan niyo pong isa-isahin ko. Isinampa ang impeachment complaint laban kay Pangulong Estrada magno-Nobyembre. Nung nag-recess ang Senado, tumigil ang trial. Nag-resume sila pagkatapos ng recess. May nagreklamo ba? May nagsabing, uy, forthwith ah. Yan ang president ng Senado. Nung nag-trial at hindi binuksan ang second envelope, yun yung maalala, nag-walk out ang prosecutors, hindi na bumalik. Anong ginawa ng Senado? Wala ng prosecutor, wala ng interesado, dinismiss forthwith yung impeachment complaint. Dahil nawala na yung prosecutors. Tama nga naman. Hindi na pala interesado yung mga prosecutor, ano pang gagawin ng Senado magtawag ng hearing? Sa kaso ni Chief Justice Corona, sinampa 5 araw bago mag-adjourn ng Senado. Nagsimula ang trial pag-resume pagkatapos ng Christmas break. Pero bago mag-break o habang break, nag-issue ng summons, nagkasagutan. Yun naman talaga yung balak natin pag-resume nitong 2 linggong ito. Yun lang, Mr. President, mga kasamaan. Ang kaisa-isang impeachment complaint na nasimulan at natapos ng Senado. Yung pangatlong impeachment complaint ni Ombudsman Mercy Gutierrez. Final yan 3 araw bago mag-adjourn ang Senado sa kanyang regular recess, walang eleksyon nun. Nung nag-resume, dun lamang sinet ang trial. Pero bago nag-resume ang Kongreso, nagbitiw si Ombudsman Gutierrez. Ano ang ginawa ng Senado? Walang trial, hindi kinonvene ang impeachment court, as a Senate, dinismiss yung impeachment complaint. Pinagpasahan nila. Resign na pala eh. Wala na tayong kailangan gawin. Naalala niyo po yung debate? Na meron pa namang penalty of absolute perpetual disqualification. That was discussed. But by way of precedent, the Senate did that. So if you look at the past presidents of the Senate, nagawa po nila yon, pinagbotohan po nila yon. Without convening the impeachment court. Wala pong nagsabi, hoy, inaabandon na ninyo ang inyong constitutional duty nung ginawa ng Senado yon. Paano po yan, Ginoong Pangulo? Pagsang-ayon ba ang karamihan o ng pinakamaingay ang matatalino sa ating bansa? Okay lang. Pag hindi sila sang-ayon, hindi na okay. Bugbog ka na. Bugbog na institusyon. Dapat may gawin na tayo. The Constitution, the rules, and the precedents, Mr. President, do not change simply because a group says otherwise. Balikta naman pa natin. Yung isang naudlot na impeachment complaint laban kay dating Chief Justice Davide. Karamihan sa mga civil society groups tutol doon sa impeachment complaint na yon. Tungkol sa corruption din yon. Tungkol sa pag-aabuso din ng poder yon. Parehong mga grounds, dahil yun naman ang ground ng impeachment talaga eh. Anong sinabi nung halos parehong grupo ngayon na gusto ang ulo ni Vice President Sara? Ay, masama yung impeachment yan. Hindi yan dapat i-file. Dapat i-dismiss nyo yan. Mabuting tao si Chief Justice Davide. Nagsalita pa ang mga miyembro ng Senado noon. Kahit padala ng Kamara sa amin, hindi namin tatanggapin yan. Sinabi din po ng Senado noong mga panahon yun. At saka busy kami sa budget. Kailangan muna namin unahin yan bago yan. Babalik ko ang katanungan. Nagbabago ba? Depende kung sinong may gusto. Hindi ba dapat kung ano yung pamantayan at batayan kaugnay ng impeachment complaint, sino man ang nasasakdal? Pareho at parehas ang pagtrato natin. Ngayon, kaugnay ng kasalukuyang impeachment complaint, nakalagay po sa rules ng Senado, ang impeachment proceedings dapat i-refer sa Committee on Justice. Ang ginawa ng Senado, bagaman pareho ang rules natin na bahagi ng ating President, ni-refer sa Committee on Rules na siyang naging hudyat para buuin ang impeachment court. Sa Estados Unidos, kung saan natin kinopya ang karamihan ng mga provision ng ating impeachment rules, ang mga miyembro ng Kamara na nag-hire ng impeachment o mga prosecutors, sila ang nagbabasa niyan. So, nung nakita po namin sa parte ng Secretariat, yung President na yon, nung nakita po namin, yung provision na dapat sa Committee on Justice i-refer, sinuggest namin na basahin yung articles of impeachment ng prosecutors mismo. Sa Senado, hindi pa sa Korte. Para magsilbing hudyat yon ng pag-convene ng impeachment court at panunumpa ng mga judges ng impeachment court. Yun po sana ang nakatalagang gawin sa June 11. Nasabi po ni Senator Villanueva, ano nga ba ang pagkakaiba? June 2, June 3, June 5, June 4, June 9, June 10, June 11. Kung susundan natin ang ginawa ng mga ibang impeachment court sa mga nagdaang panahon, ini-issue lamang nila yung summons para mabigyan ng sapat na panahon. Ang nasasakdal na isumite yung kanyang answer dyan sa impeachment complaint. At pagkatapos nun, dahil magtatapos ang kapangyarihan ng mga prosecutor sa June 30, hindi po tayo pwede magpatuloy sa ating paglilitis dahil hindi naman pwedeng one side lang yung ating mapapakinggan pagkatapos ng June 30. Doon sa nagsasabi na may mga private prosecutor naman na i-appoint ang Kamara. With the principal goes the agent because the authority of the principal ceases by June 30. So, napag-usapan, tatawid ba ito? Tatawid ba ito sa susunod na Kongreso? Kung gaano rin karami siguro ang senador, ganun karami din ang opinion. Kung gaano karami ang abogado, ganun karami din ang magaling nilang basehan kung tatawid nga ba o hindi. My position is that it will. Mr. President, Your Honor, allow me to read a portion of the deliberations of the Constitutional Commission on this matter. Delegate Aquino. Because I would proceed, quote, from settled jurisprudence that impeachment proceedings are essentially judicial in nature, such that it follows that when the legislative chamber undertakes these proceedings, it sits as a court of justice, and therefore, it is not bound by the rules of legislative sessions. It cannot adjourn. Assuming that the session is adjourned, impeachment proceedings should not in any way be affected by the adjournment of the session. Delegate Romulo. That is not precluded from our proposal. If the commissioner wants to make it explicit and to suggest amendments to that effect, I suppose I would not object. Our thinking is that if the commissioner's premise is that it is like a court of justice, maybe an adjournment of the hearing will certainly not preclude it from continuing the proceedings on some other day. In other words, it could not lose jurisdiction just because of adjournment. Add to that, Mr. President, what the minority leader said during earlier sessions we've had. Hindi porkit pinalitan yung judge, dismissed agad lahat ng kaso at magsisimula uli. Ang prinsipyo pa ng batas na nagsasabing anumang sinimulan, dapat lamang tapusin. Plus ang president natin, kaugnay sa SET, na tumatawid yung kaso sa SET, bagaman nagpalit ng Kongreso, bagaman nagpalit ng mga miyembro ng Senado at maestrado ng Korte Suprema. Now, allow me to state a few more things before I yield the floor. Mr. President, Congress cannot pass an irrepealable law. Very much so that we cannot bind the next Congress. Whatever we decide with respect to this issue, kung tatawid nga ba o hindi, would have to be confirmed, affirmed, or rejected as the case may be by the 20th Congress. Some of us will be part of that. Some of us will no longer be part of that. But we cannot tie their hands and bind their hands. But the same is true, Mr. President, Your Honor, if at all, with the House of Representatives as well. The 19th Congress also, to my mind, cannot bind. If the 19th Congress Senate cannot bind the 19th Congress, the 20th Congress Senate, then in the same breath, the 19th Congress House cannot bind the 20th Congress House. certain procedural, to my mind, compliances need to be made in order for this to be done. As a last point, Mr. President, Your Honor, oo nga po at marami nagpapahayag na opinyon at maraming sinasabi laban sa Senado at higit pa sa sinumang miyembro ng Senado laban sa inyong lingkod. But I consider that as part of the burden of leadership, Mr. President, Your Honor. Bahagi yan ng trabaho bilang tagapangulo ng Senado na balikatin kung anumang pagsubok, anumang pasanin, anumang patutsada na ibabato sa Senado o sa tagapangulo ng Senado kaugnay ng ginagawa o di nito ginagawa. Pero alalahanin din sana ng ating mga kababayan, bagaman karapatan nilang sabihin at magsabi ng kanilang nasa sa loob, tulad ng paggalang na ginagawa natin sa mga nagpapahayag ng kanilang opinyon sa labas lamang ng Senado. Para po sa akin, lahat po ito ay welcome at respetado ko dahil sa isang demokrasya, importante ang malayang pagpapahayag ng opinyon. Sa isang demokrasya, Ginoong Pangulo, hindi naman pwedeng nagkakasundo tayo sa lahat ng bagay. Sa isang demokrasya, tama lang, okay lang at dapat lang na magkakaiba tayo ng pananaw basta't hindi tayo nagsasakitan, basta't hindi tayo nag-aaway o dumarating sa punto na magkakasakitan. Malaya tayo makakapagdebate pero sa dulo, tulad lamang ng nakarang eleksyon, pagbobotohan po natin ito at ito'y masesettle sa pamamagitan ng botohan. Sino man ang manalo sa botohan, hindi nangangahulugang tama. Sino man ang matalo, hindi nangangahulugang mali. Iyon ang gusto ng nakararami. Gayon din sa mga opinyon na inihahayag sa ngayon. Hindi porkit yan ang tingin ninyo, tama na kayo. Hindi porkit na hindi sang-ayon ang ibang tao sa inyo, mali na sila. Hindi po ganun yun. That I am not, or anyone here in the Senate is not on your side, does not mean that they are wrong and you are right. Only history will be the judge of that. Kaugnay naman ng mga legal na opinyon. Dapat ganito, dapat ganyan, ito ang forthwith, dapat ngayon na, dapat bukas, pwede sa Miyerkules. Ang pwede lamang po naman magpasya ng legalidad niyan ay ang Korte Suprema. Hanggat hindi po nangyayari yan, malaya tayong pwedeng magdebate at sabihin ang ating kanya-kanyang posisyon na buong na bukas at buong pahintulot ang binigay ng Senado para mapakinggan yan. Hindi lamang sa iba't ibang social media platforms, pati dito sa plenaryo ng Senado. Again, Mr. President, before I conclude, I thank our colleagues for enunciating their opinion, their positions on this matter, and for the healthy debate that we saw and heard regarding this matter. As stated by Senator Tulfo earlier, at some point in time, we will have to put this to a vote. And as I believe, we will put this to a vote in the next few minutes. Hiling at dalangin ko, ano man ang maging resulta na ninanais ng mas nakararami, galangin ng kada at bawat miyembro ng Senado. Dahil sa dulo, tagapangulo man ako ng Senado, batikang senador ka man o baguhan, tigi-tigisa lang po tayo ng boto. Pantay-pantay po tayo pagdating sa kapasyang ito. Maraming salamat po sa inyong pasensya, sa oras at paumanhin kung medyo mahaba-haba po ng konti ang aking mga sinambit na salita. Salamat po at salamat sa pasensya at sa oras na binigay ng ating Minority Floor Leader.
Maraming salamat. The Office of the Vice President, open and close parenthesis OVP, and the Department of Education, open and close parenthesis DepEd. Article 3, respondent betrayed the public trust and or committed bribery and or other acts of graft and corruption in violation of Republic Act number 3019. Article 4, respondent committed culpable violations of the Constitution and or betrayal of public trust in amassing unexplained wealth and failing to disclose all her properties and interest in properties in her statement of assets and net worth, open and close parenthesis, SAL-N, in violation of Section 17, Article 11 of the 1987 Philippine Constitution. Article 5, respondent committed other high crimes, including the high crime of murder and conspiracy to crimes, including the high crime of murder and conspiracy to commit murder. Article 6, respondent by herself and or in concert with others committed acts of destabilization constituting at least a betrayal of public trust and or culpable violations of the Constitution, and even the high crimes of sedition and insurrection. Article 7, the totality of respondents' conduct as Vice President, including her commission of the foregoing acts, clearly display conduct constituting a betrayal of public trust, culpable violations of the 1987 Constitution, and graft and corruption. These allegations are serious. They demand nothing less than a prompt and faithful discharge of our constitutional duties. Actually, all matters of impeachment are serious and important. Just look at the grounds provided by the Constitution. Culpable violation of the Constitution, treason, bribery, graft and corruption, other high crimes, and betrayal of public trust. The Senate President refused to convene the Senate as the impeachment court from February to May 2025 because he believes that the Senate could not act on the articles of impeachment while it was not in legislative session. We have an honest difference of opinion on this matter. For the record, I believe that the Senate has a separate existence as the impeachment court from the Senate, which is a part of the legislative department. The Senate, as the impeachment court, is governed by Article 11 of the 1987 Constitution. The Senate, as a part of the legislative department, is governed by Article 6. In short, legislative functions of the Senate are found in Article 6. The other functions of the Senate found outside of Article 6 of the Constitution are therefore what we can call the Senate's non-legislative functions. This conclusion is bolstered by the case of Pimentel Jr. versus Joint Committee of Congress, which involved the function of the Senate as part of the National Board of Canvassers for President and Vice President, a function which is found in Article 7 of the Constitution. The Supreme Court ruled in this case that the legislative functions of the 12th Congress may have come to a close upon the final adjournment of its regular sessions on June 11, 2004, but this does not affect its non-legislative functions. What is more important to me is the entry in the judgment which states as follows. In sum, despite the adjournment sine die of Congress, there is no legal impediment to the Joint Committee completing the tasks assigned to it and transmitting its report for the approval of the joint public session of both houses of Congress, which may reconvene without need of call by the President to a special session. I want to focus on the phrase, without need of call. There shall be no need of a call because the Constitution itself recognizes Congress's existence as the National Board of Canvassers for the presidential and vice presidential elections and mandates the holding of a joint public session. So in short, the source of the existence of the body and the authority and power to carry out its function and duty is the Constitution itself. It is therefore undeniable that the Senate has duties and functions that are not legislative in nature. As an additional argument, still on this honest difference of opinion, let us look at Article 6, Section 19 of the Constitution. Meron naman yung copy ng rules natin dyan ng Constitution. This section talks about two bodies of which Congress, including the Senate, is a member of: the electoral tribunals and the Commission on Appointments. There is a sentence here in that section that the Commission on Appointments shall meet only while the Congress is in session. Meaning to say that if the sentence were not in the Constitution, then the Commission on Appointments can meet even while the Congress is not in session. The electoral tribunals can therefore meet even when the Congress is not in session because there is no such sentence applicable to the electoral tribunals. Unlike the provisions concerning the Commission on Appointments, there is no similar constitutional limitation found in Article 11 on when the Senate as the impeachment court can convene, meet, or hold sessions in order to perform its functions. Ulitin ko, wala pong sinasabi na ang Senado as the impeachment court shall meet only while the Congress is in session. Wala. Wala po yan. Clearly, therefore, the Senate as the impeachment court could have proceeded with the trial of the articles of impeachment even if the Senate as a legislative body was not in session. But that period of time from February to May 2025 is lost time already, like water which has passed under a bridge. To remedy the situation, let us focus on the here and now. Per the proposed calendar of the impeachment trial, attached as Annex A to the letter of the Senate President addressed to all senators dated February 24, 2025, we were supposed to have allowed the panel of prosecutors to present the articles of impeachment on June 2, 2025 at 3 p.m. and to have convened the Senate as the impeachment court on June 3 at 9 a.m. I am also submitting a copy of the letter of the Senate President dated February 24, 2025 with its Annex A to the Secretariat to form a part of the records of the Senate. It is stated in the said Annex A that the Senate hopes to adhere to the foregoing schedule and considering that both the prosecution and defense will have ample time to prepare for the proceedings, will not tolerate any dilatory motion or pleading. Before June 2 arrived, on May 29, the Senate President vacated this proposed calendar of the impeachment court and transferred the presentation of the articles of impeachment by the panel of prosecutors to June 11, 2025, which is a critical date because that happens to be the last day of the legislative session of the Senate per our existing legislative calendar. Last Monday, June 2, 2025, when I asked the Senate President before the plenary on the American practice in impeachment proceedings regarding the appearance of the prosecutors from the House of Representatives, the Senate President answered me with, and I quote, "That in turn will now trigger, if at all, the convening of the impeachment court where the regular processes would now be followed." Diyan po kami natakot, diyan sa qualifier na if at all. That inserted qualifier casts doubt on whether the Senate leadership will follow what is otherwise a clear constitutional command. It suggests that even after the articles of impeachment have been read and presented, the convening of the impeachment court might still be discretionary or optional. This use of the if at all phrase has not escaped the notice of our citizens. The situation is exacerbated by the pronouncement of the Senate President that, in the end, Senate plenary is supreme. Add to this the circulation of a resolution, although admittedly a draft, declaring the impeachment case de facto dismissed. Can we therefore blame law professors, lawyers groups, civil society groups, known legal personalities, and even ordinary citizens for raising the alarm of a no-trial scenario? So how do we and can we remedy the situation we are right now? The remedy is simple. As senators, we have taken an oath to support and defend the Constitution of the Philippines, that I will bear true faith and allegiance to the same. Let us follow what the Constitution says, most especially those provisions which are directed at the Senate. Sabi ng Konstitusyon, trial by the Senate shall forthwith proceed. There is no if, no unless, no when convenient. Indeed, the Senate has a constitutional duty to hold the trial of an impeachment complaint, especially when it has been filed by at least one-third of all the members of the House of Representatives, like in this case against the Vice President. Trial is the most fair course of action because the people need to know if their representatives acted properly and justly by hearing the evidence used by them in filing the impeachment case. And in the name of due process, we need to give the impeached officer the chance to defend himself or herself and clear his or her name. Klaruhin ko na ang pinag-uusapan natin dito ay kung ano ang constitutional duty ng Senado, hindi kung guilty or not guilty na ba ang impeached officer. Saka na ang hatol pagkatapos na ng trial. Ang importante ay mag-umpisa na ang trial proceedings kasi yan ang utos ng ating konstitusyon. Mr. President, my dear colleagues, any further delay not only undermines the explicit mandate of the Constitution and our rules, it risks eroding public trust in the Senate's capacity and capability to uphold the accountability of public officers and the rule of law. Not only do many believe that the Senate is heading to a no-trial scenario, worse, many have opined that simply by inaction or by merely refusing to convene as the impeachment court, the Senate seems to believe that it can effectively dismiss or defeat an impeachment complaint duly filed and transmitted by the House of Representatives. Under Rule 10 of the Senate's Rules of Procedure on Impeachment Trials, at the hour of the day appointed for the trial of an impeachment, the legislative business of the Senate, if there be any, shall be suspended so that the business of the trial can proceed. So in the light of all of this, and in accordance with our solemn duty under the Constitution, I most respectfully move, number one, that our legislative business be suspended. Number two, that we already convene as the impeachment court at this very moment. Number three, that the Senate President immediately take his oath as presiding officer of the impeachment court. Number four, that thereafter, the Senate President / presiding officer administer the oath or affirmation to all the members of the Senate now present. Number five, that the impeachment court then call the impeachment case against Vice President Sara Duterte and come up with a calendar for the trial thereof. Number six, that tomorrow, June 10, 2025, at 2 o'clock in the afternoon, the impeachment court call the impeachment case for the presentation and reading of the articles of impeachment by the panel of prosecutors of the House of Representatives. And number seven, that thereafter, the writ of summons be issued to the impeached officer. So I so move, Mr. President.
What is the pleasure of the Honorable Ontiveros?
Salamat, Abi, Mr. President. I wish to second the motion of the Minority Leader through a manifestation.
All the motions of the Minority Floor Leader?
That is correct, Mr. President.
Duly noted.
May I deliver my manifestation seconding the motion of the Minority Leader, Mr.
The lady may
President?
proceed.
Salamat, Abi, Mr. President. I second the motion of the good Minority Leader. Forthwith, and with no further delay, the Senate President must be placed under oath as presiding officer. He must then administer the oath to the members of the Senate as judges of the impeachment court. And most importantly, the articles of impeachment, which have long languished in limbo, must forthwith be presented to the body. First of all, the Constitution establishes with clarity the mandatory nature of impeachment, and this textual interpretation is supported by the framers. Article 11 on accountability of public officers, Section 3, subsection 4, states in no uncertain terms that once, quote, the verified complaint or resolution of impeachment necessary implication, it would by necessary implication have the power to alter or amend the meaning of the Constitution without need of referendum, close quote. Wala pong kapangyarihan ang Senado na iwaksi ang malinaw na utos ng saligang batas. Hinihimo ko po ang pinuno at mga kasamahan ko sa Senado, sundin po natin ang malinaw na mandato ng saligang batas. Galangin po natin ang taong bayang nagbigay ng tiwala sa atin at simulan na po natin ang impeachment trial na ito. Dapat ay madali ang dinggin ito at ang paglilitis, sinsero at hindi minamadali. Takulang pasasalamat, Mr. President.
Duly noted and entered into the records. What is the pleasure of the Honorable Senator Tolentino?
Mr. President, we heard a few minutes ago the the statement delivered by the distinguished minority leader. And it would appear, Mr. President, that multiple motions were inserted calling for a ruling, not just from this body, but from the chair. As a point of information, Mr. President, may we know from the distinguished minority leader if he can just subdivide what is the main motion, what is the subsidiary motion, what is the incidental motion, because it appears now that this is confusing, Mr. President, especially on a matter of transcendental and constitutional importance, Mr. President.
With the permission of the Senate President.
Before recognizing the Honorable Minority Leader, what is the pleasure of the
Thank you.
Honorable Villanueva?
Thank you, Mr. President. Thank you, Minority Leader, Majority Leader. With the indulgence of our dear colleagues, this might be a prejudicial question before we actually dispense with the motion of the Minority Leader. But first things first, Mr. President, let me state for the record this representation's position from day one, Mr. President. The word forthwith, the crossing from 19th to 20th Congress, everything that the Minority Leader mentioned, Mr. President, ay sinishare ng representation na ito. Kailangan mag-convene ang impeachment court, kailangan magsimula. Ngunit naniniwala din po ako, Mr. President, and since day one, when the Senate President made mention about the June 2 schedule, this representation did not oppose nor pose an objection in this August chamber, Mr. President. Because I believe what the Senate President is doing. When he extended it to June 11, I don't see any reason, or I would say undue delay, unnecessary delay, etc., because I think all of us here during that time would agree that the trial would commence on the 20th Congress. And having said that, Mr. President, let me just put into the records, Mr. President, our own rules, Mr. President, in the rules of impeachment, Rule 1. The Senate President must actually issue a notice, Mr. President, to the House of Representatives. And that's the reason why he wrote a letter in June 2 and then
May something.
June 11, Mr.
May
President.
11, May.
If I heard it right, Mr. President, and that's why I wanted to be clarified on this particular issue, if I heard it right, the Minority Leader's motion is for us to stop legislative work and start taking the oath of the Senate President as the presiding officer of the impeachment court and the senator judges. It would also mean, Mr. President, that we assume that the impeachment proceeding, the articles of impeachment had already been referred, Mr. President, because we have not. And so let me just put that on record, Mr. President. And again, I thank the Minority Leader and again share his views about the immediate convening of our impeachment court. And I don't see any reason, Mr. President, why we should convene now than on Wednesday, Mr. President, which is 2 days from now. Thank you, Mr. President. Thank you, Minority Leader.
So, Mr. President, so that we can
The Minority Leader will respond to the
so we can dispose of the pending
clarification
matter.
asked for
Yes.
by Senator Tolentino. Yes.
Yes.
You may proceed, sir.
So that the body can properly act on the pending matter, which I have raised in my question of privilege based on our rules. I therefore move that we already convene as the impeachment court at this very moment, Mr. President. That's the motion, Mr. President. And We expect the ruling.
If I may, Mr. President. If I may, I have already mentioned earlier, Mr. President, and because this representation wouldn't want to raise a point of order. And again, for the record, I share the sentiments of the minority leader. We have the same position as to the convening of the impeachment court. We have the same position as to whether or not it will pass through the 19th to 20th Congress. It's the same, Mr. President. But again, I don't want to raise a point of order, Mr. President, but in our rules, Mr. President, you yourself, in Rule 1 of the Rules of Procedure on impeachment trials, let me quote, Mr. President, when the Senate receives articles of impeachment pursuant to Article 11, Section 2 and 3 of the Constitution, the President of the Senate shall inform the House of Representatives that the Senate shall take proper order on the subject of impeachment and shall be ready to receive the prosecutors on such time and date as the Senate may specify. So, Mr. President, I wanted to find out if the motion of the minority leader will push through, what would happen, Mr. President, if you have not issued any notice, Mr. President? What would happen to your letters na from June 2, ginawa nating June 11? Does it also mean, Mr. President, na baliwala na po ito? So, that is just a procedural question, Mr. President. And again, let me put again on the record that I have the same position as the minority leader, that if we can convene as much as possible, Mr. President, the impeachment court, I would go for it, Mr. President. Thank you.
Mr. President, there
Before
is no,
Senator De La Rosa, the Honorable
there
Pimentel.
is no basis to raise a point of order because no provision or section of our rules has been violated. And that factual question from our colleague that the Senate President shall take proper order on the subject of impeachment has been done. There is a letter from the Senate President to the House dated May 19, 2025.
Which will be on June 11, Your Honor.
No. Hindi na po ito. Ang ibig sabihin lang po nito, itong ating Rule 1 ng ating Rules on Procedure on Impeachment Trials. Sabihin lang ng Senate President sa House that the Senate has taken proper order of the subject of impeachment and we are ready to receive the prosecutors on such date and time that we will tell you. So yun na po yun. So I think this has been satisfied by the does the Secretariat confirm the May 19, 2025 communication from the Senate President to the House of Representatives? Tama po ba?
But at the same time, na-refer na ba yung ano?
The Secretariat confirms a letter dated May 19, setting the convening of the impeachment court supposedly on June 3, which was later on amended at a later date, setting it on June 11. Before recognizing the Honorable De La Rosa, Chair would like to make of record that as stated in the February 24, 2025 letter of the Chair to all the members of the Senate, where we quoted all the relevant Supreme Court decisions and rules and the basis for the action of the Senate President and Chair, namely, citing precedents as well as the practice both in the past by the Senate of the Philippines and by the U.S. Senate, na nagsasabi, kailangan mabasa in open session ang articles of impeachment. This is clear from the practice in the United States where we lifted, as the gentleman previously stated, more than a majority of our rules, and this was also done in the impeachment complaint. The only impeachment complaint that actually went through to the end during the impeachment trial of Chief Justice Corona. The impeachment articles were read in plenary before it was referred to the impeachment court. However, it was done by the majority leader at that time. That was the first time it was done, not written in our rules too, but when the Secretariat checked precedents and practice in the United States, it was actually the House prosecutors that did it, or who usually does it in the United States. Hence, the notice given for the June 2nd, June 3rd reading by the House prosecutors of the articles of impeachment. Thereafter, that will now be referred to the impeachment court, which will give rise to the creation of the impeachment court, the oath of this representation, as well as the members of the Senate, and the convening of the court to approve its rules and to set the calendar of the court, both either in this Congress or in the next Congress. For the record, as stated by Senator Villanueva, and as I stated, both off the record, meaning in media interviews, that the chair is of the belief that this will cross over to the 20th Congress, very much like the citations given by the Honorable Pimentel, not only because presidents in the U.S. so state, we have our own precedents too with respect to the Senate Electoral Tribunal, where the questions pertain to a term spanning 6 years, which therefore crosses over to the next Congress, despite the fact that the members of the Supreme Court constituting the SET and members of the Senate constituting the SET have been changed in the course of the change of the new Congress. And finally, as a point, Chair also made known its position that as a general rule and as a general principle, the law frowns upon starting something and not finishing it. Tulad na lamang ng mga kaso na kabinbin sa korte, hindi porkit nagpalit ng judge o nagpalit ng mga maestrado ng korte, automatic dismissed yung kaso. Magpapatuloy yung kaso hanggang yon ay matapos. Before recognizing Senator Pimentel, may I ask, what is the pleasure of the Honorable De La Rosa, who was earlier raising his hand in the middle of the discussions?
Mr. President, if I may, just very quick,
With the permission
Mr. President,
of the
with the
Honorable
permission
De La
of
Rosa,
my two colleagues,
The
Mr.
Honorable
President,
Pimentel, the Honorable
very
Cayetano,
short,
Senator
Mr. President.
Villanueva is
Very
recognized.
short. Thank you very much, Mr. President. Very short lang, Mr. President. Again, I am in the same position of the minority leader, but I just wanted to make sure that we are doing the right thing, the right process, and that we are, because we are men of rules, Mr. President, we wanted to make sure that we are in the right position to do this. The reading and the referral of the articles of impeachment in session, Mr. President, was done during the impeachment of former President Estrada, November 14, 2000. During the impeachment of Ombudsman Gutierrez, it was also referred, Mr. President, in session, during the last day of session, March 23, 2011. In the impeachment of Chief Justice Corona, it was also referred, Mr. President. It's just that, that's why, Mr. President, I just have this belief that we should refer first, Mr. President, before we can make that motion. And I will join the gentleman from the minority, Mr. President. Thank you, Mr. President.
Noted. Senator, what is the pleasure of the Honorable Cayetano?
Thank you, Mr. President. Mr. President, I just have to be clarified on some points, and this is in relation, of course, to the minority leader, the deputy minority leader, and to our former majority leader. So if I may proceed and just lay out the basis for my inquiry.
The
First,
gentleman may proceed.
Well, first, let me start out by saying I pray for wisdom for all of us, and I ask everyone to continue to pray for wisdom for us. I also like to state before I say my inquiry, it's unfair to just blame the Senate President. 23 naman tayong senador eh. Conscious naman tayo lahat nung February 5. Nandito naman tayo, pwede naman tayo mag-object ng, nung nag-adjourn, nung final yan. So, as the minority leader said, nandyan na yan, wag na natin tignan yung nakalipas. Forward na tayo, no? Second, I just want to comment dun sa mga law schools. I appreciate it, and I'm happy they're very active, and I'm happy that they have statements. But may I advise them also to be consistent? Kasi si Congressman Cardema nag-file ng impeachment laban sa Pangulo. Hindi tinanggap sa House eh. Wala naman ako narinig na mga sinasabi na dapat ang konstitusyon masunod at dapat tinanggap ng House yan. So, of course, hindi naman trabaho ng mga law schools na in each and every impeachment case magsalita, pero in a highly charged environment. Can you imagine, Mr. President, during the campaign, sa mismong media interviews ng top news channels natin, tatanungin yung kandidato, pag kayo nanalo, are you for or against the impeachment case? Klaro naman ang sagot doon eh. Ang sagot doon, hindi kami pwede mag-comment kasi magiging judge kami. Pero hindi. Sinagot pa rin ng mga kandidato at tinanong pa rin ng media. Pero kung konstitusyon ang masusunod, ang sagot doon iisa lang, mag-o-oath kami, dapat neutral kami. Kaya lang eleksyon eh. Kasi masama naman talaga timing ng pagka-file nito eh. Magpa-file ka during the campaign. That's the reality there. Kaya nga sa US, pagka-jury system, pwede mo i-sequester yung jury eh. Papayag ba tayo nung February na i-sequester tayong 23? Na ikukulong tayo at hindi tayo makikinig sa kahit anong media at i-determine natin ito? Maybe may papayag sa atin, meron hindi. But wag na tayong magsisihan. So, I'll go to my question. So, maybe that's why Shakespeare said, if you want justice, first kill all the lawyers. Diba? Kasi nga, labanan ng mga abogado to. Pero, hindi ibig sabihin na wala silang mga personal na bias nila. Mahirap magsalita dito na insulto sa lahat ng Pilipino to. Ito ang gusto ng taong bayan. Ang daming lugar sa buong Pilipinas eh. Yung Duterte nanalo eh. Ang kampanya nila, wag ituloy yung impeachment eh. So, sasabihin ko ba na yun ang will ng tao? Pero kung titingnan ko naman lahat ng comments ngayon sa Facebook, sa SOCMED, gusto naman ituloy. Pati si Vice President Sara, sabi niya, I want to be held accountable. So, siya yung ba sabihin ko, yan ang gusto ng taong bayan. Napakahirap po nung sitwasyon natin. That's why we need wisdom. But first question ko po, prejudicial question. Ano bang rules ang unang masusunod? Rules ng Senate o rules ng impeachment? Bakit to importante at bakit to prejudicial question? Tinitignan ko po kaninang umaga yung comment, allegedly, hindi ko sure, wala naman nakalagay doon na siguradong totoo yun, but meron pong comment ang defense team ni Vice President Sara Duterte. Correct me if I'm wrong, Senator Bato, Senator Bongo, my good friend, my brother, Senator Robin, kasi hindi ko alam kung official yon. To paraphrase, ang sabi nila, hindi magandang mag-comment sila, but they'd like to reiterate na tingin nila labag sa konstitusyon yung impeachment complaint na to dahil ito'y pang-apat at lumalabag to sa isang complaint sa isang taon. Okay. Kung yun ang stand nila, sino po ang hihimay sa issue na yan? Ang plenary ba under the Senate rules? Or yung impeachment court under the impeachment rules? Bakit ko po ito sinasabi? Kung may pinadalang bill ngayon yung House of Representatives, halimbawa dyan sa 200 pesos, at second reading pa lang halimbawa siya, pag ni-refer natin sa Committee on Rules natin yan, magbabay-cam na ba kagad tayo o sasabihin natin, sandali lang, second reading pa lang sila, kailangan mo ng third reading pa lang. Ang sinasabi sa akin ni Senator Villanueva ngayon, pinadala lahat ng records except for the bill that they passed. So we cannot act on the 200 peso minimum wage, additional sa minimum wage. But that's my point, Mr. President. Sino po magde-decide? Tayo po ba as senators o tayo as senator judges? Kung nilabag ang konstitusyon doon. And doon naman ako sumasang-ayon sa mga law schools. Let's proceed. Let's look at it. But yun nga ang question. Yung complaint ba is firm, legal, according to Constitution, or may constitutional infirmity ito? My last question is just a question of logic. Nag-move yung ating minority leader na to convene na as a impeachment court. Yung ating deputy, sabi niya, hindi na kailangan magbotohan. Pag nag-move ka, may botohan. So, sino masusunod sa dalawa? Why do I say this? I'm saying it not because it's funny, that one will move and then kailangang magbotohan and the other one will move na magbotohan. Kung matalo botohan, sabi niya, hindi kailangan ng botohan I say this for a simple practical reality. When you say the Senate, it is composed of 24 or in this case, 23 senators. So pag sinabi mong gumalaw ang Senado, ibig sabihin po, either walang nag-object or may botohan at yung majority masusunod. I cannot say right now, like Senator Villanueva, that I'm 100% in agreement with Senator Coco and Senator Risa. I can tell you I'm in agreement with certain things they've said. For example, Mr. President, it's our constitutional duty. Kailangan mag-proceed. We should have done it earlier. But again, I won't blame you. I won't blame them. I'll blame myself. I could have written you a letter. I could have said na February, mag-ano na tayo. But let me just explain that one point. Why didn't I write you a letter, Mr. President? Kasi pag Pangulo yung ini-impeach, every single day na nandyan, kung totoo ang allegation sa Presidente, we all suffer. The country suffers, our institution suffers, accountability suffers. Pero pag Vice President, especially ngayon, hindi naman siya binigyan ng ibang trabaho Wala naman siya sa kabinete. Yes, I want accountability. Pero between today and Wednesday, I'd rather pass yung Konektadong Pinoy at saka yung e-government at lahat ng ibang bills na naka-pending dyan. So, Mr. President, may I end by reiterating the question. Do we follow first the rules of the Senate or do we go into the impeachment court? Sino magde-decide nung allegations ng defense na na-violate ang Constitution sa one impeachment per year? The second is just to continue my observation, Mr. President. I agree with many here. Wala tayong choice, forthwith. But I disagree na sa Tagalog, agad-agad ang forthwith. Ang forthwith, yung ibig sabihin nun sa Tagalog is yan na yung susunod. Yan na yung gagawin mo. Oo, immediate yung agad-agad. Hindi ako expert sa linguistics, pero medyo hindi agad ang Tagalog ng forthwith. Yung immediately, yon agad yon or agad-agad, di ba? So, maya-maya, hindi, ibig sabihin ng forthwith, sang-ayon naman ako Ang ibig sabihin ng forthwith, wala ka nang to quote dos por dos, susunod na. O yun ang ibig sabihin ng forthwith. Yung wala ka nang hihintayin, yun na. Kaya agree ako sa inyo na kailangan talakayin natin yung impeachment complaint. Pero gusto kong iklaro, sa tama o sa mali, botohan ang mangyayari sa atin. Hindi pwede pong bumoto yung 15 na hindi magko-convene yung impeachment. Tapos 9 kami o 8 tayong magpapakita doon na naka-robe. Kasi sinabi ng 15, hindi magko-convene Anong pwedeng gawin? Pupunta ka ng Supreme Court, uutusan tayo ngayon ng Supreme Court. Yun ang legal system natin, Mr. President. So sana tama desisyon natin para hindi na tayo maghintay na utusan pa tayo ng Supreme Court. Pero yung sabihin na walang botohan dito, I agree with the spirit nung sinasabi ni Senator Risa na dapat wala na. But the practical reality is that you have one senator who asked for a vote. We have to vote and the majority will follow. But yun nga, Mr. President, reiterate ko lang yung tanong ko. So dito po sa one-year rule, sino po magde-decide niya? Is it the Senate sitting as legislator, so rules muna ng Senate? Or is it the impeachment court? Because if it is the Senate, we cannot yet convene as an impeachment court because we haven't tackled that issue. But if it is the impeachment court, then we can go, and that's the first issue that we will have to tackle, whether it is a valid complaint. No? At tinatanong ko lawyers ko, hati din po Sabi nung kalahati, hindi, dapat yung Senate kasi it's treated like any other legislative matter. Titignan muna natin kung tama yung pagka-transmit sa atin. Malay mo, transmit sa atin, nahack pala. Hindi pala galing sa House of Representatives. That might sound like a silly example, but it is. It is possible. That's why we have to look at it. Thank you, Mr. President.
Before the chair responds, chair would like to afford the opportunity to the other members who would want to add to the discussion and the knowledge being imparted regarding the subject matter at hand.
So, President, Senator De La Rosa is seeking the
Senator
floor.
De La Rosa was earlier raising his hand but gave way to Senators Villanueva and Cayetano. What is the pleasure of the Honorable De La Rosa, sir?
Thank you, Mr. President. Mr. President, according to Senator Cayetano, ito'y labanan ng mga abogado. Hindi po ako abogado, Mr. President, but I just would like to manifest my observation na to be fair to the Senate President, pag sinabi natin na you have an intention to delay the impeachment proceedings, I would like to state for the record, Mr. President, na 1 month ago pa, pinagawan muna kami ng robe, Mr. President. Kasi excited na tayo na sumuot ng robe para to form the impeachment court. To be fair with you, Mr. President, you've been preparing for that. And yung schedule natin na naka-schedule sa Wednesday, which is 11, if we give the ruling today, whether ano ba talagang gusto natin, today or Wednesday, I support you, Mr. President, kung anong gusto natin schedule. Sana mapag-usapan natin ngayon. Hindi ako abogado, pero ako ay isang Pilipino na gusto sana na hindi na tayo magkakagulo sa Pilipinas. Hindi tayo magkawatak-watak. At yung mga nagyayabang dyan, na sabi nila, gusto daw ng taong bayan, na ito ay talagang magkakaroon na kagad ng impeachment, taong bayan, ginagamit. I don't know kung sinong taong bayan yung sinasabi nila. Because, alam ko, Mr. President, halos lahat ng tao ng Mindanao at ng Visayas, as I have observed during the campaign period, ang sabi sa atin is, Sir, ibubuto kita kung hindi ka magboto sa impeachment or hindi ka magboto sa conviction. Yun ang sinasabi ng taong bayan. Kaya please, do not use the term taong bayan palagi because taong bayan is hindi lang kayo. There are always two sides of the coin. Bakit ba? Wala bang value yung mga taong bayan na nagsasabi na ayaw namin ng impeachment? Gusto nila? Ang ibabalyo ng Senado ay yung mga tao lang na nagsasabi na forthwith kuno yung impeachment na yan. Ano, kalimutan na natin yung ibang tao na majority na nagsasabi na ayaw namin ng impeachment dahil panggugulo lang yan sa ating bansa. Lalo tayo nagiging divided. Lalo nasisira ang ating ekonomiya. Mga investors umaalis na dahil ang gulo ng Pilipinas. So yun lang po, Mr. President. I am 101% supporting you. What's your stand, Mr. President? Thank you, Mr. President.
Noted and entered into the records. Senator Ontiveros, our Deputy Minority Floor Leader, is recognized.
Salamat po, Mr. President. I a comment on the second point of the good gentleman from Taguigan Pateros, because there's nothing funny or illogical in and between the motion of the minority leader and the seconding of this representation. The motion of the minority leader is to convene at this very moment. That is what is to be subjected to a vote. Now, instead of on Wednesday. To convene at all is not to be voted upon. Sa usaping yan, sundin lang natin ang konstitusyon. Salamat, Mr. President.
Mr. President. Sir President.
With the indulgence of Senator Pimentel, Chair recognizes Senator Cayetano, thereafter Senator Pimentel, thereafter Senator Padilla. Senator Cayetano, you may proceed.
Mr. President, I don't want to further the division or the debate, and I wasn't making fun of it. Ang sinasabi ko po, the reality is may tama't mali, may moral, immoral, may legal at illegal. Hopefully, dun tayo parati sa tama. Hopefully, ang legal, yun din ang moral. Ang problema in a collegial body, Senate, House, Commission on Appointments, we move as one based sa pagboboto. So it's just showing the irony that if the minority leader was moving that we've convened now, and the deputy minority leader was saying, you don't need a vote. But if you can vote whether it's now or Wednesday, then I can also argue, then I can also move na saka na. If you can vote whether today or Wednesday, then you can also vote na next Monday or next Thursday. So that is the paradox we are in today. So whatever decision we make, sana may wisdom. Sana matupad ang konstitusyon, dapat matupad ang konstitusyon, dapat ang kalooban ng ating mga kababayan. But the reality is po, we will be acting as a body and the vote will matter. So yun lang po, and I don't have a debate. I respect what the majority and deputy minority leader has stated. You know, as I said, some of what they say I agree with, but we have to find it in our hearts that even if we disagree, we support the chamber.
Senator
President.
Pimentel, thereafter
Yes.
Senator Padilla. Senator
Just-
Pimentel, you may proceed.
Just to respond to some of the points raised by Senator Joel Villanueva. Yan, mahirap kung nasisingitan, Mr. President. Nalilimutan natin yung topic. Mr. President, siguro i-inform ko lang yung body, no, na yung referral of an impeachment of the articles of impeachment to the Committee on Rules is not found in the rules of the Senate as a legislative body, and it's not found in the rules of the Senate as the impeachment court. So you cite past practice. Okay. But then,
It's the reading.
I don't think the Senate President will dispute my projection or my anticipation that he intended actually to introduce something new. For this particular impeachment case, he will refer it, the plan of the Senate President is to refer the after the reading, no, the read articles of impeachment directly to the impeachment court. So ibig sabihin nun, talagang pwede tayong mag-introduce ng innovation because the past practice is not supported by the letters of our two sets of rules, Mr. President. So, ang aking point is, we can actually case. We will know when we ask the clerk of court to call the case or